Good morning, everyone, and welcome to this webinar on the new edition of the EUIPO Guidelines entering into force on the 1st of March. The purpose of today's webinar is to present the most relevant changes introduced in the Office's guidelines during the 2020 revision cycle. As you know, this revision is carried out by our Knowledge Circles, and Knowledge Circles are the cross-departmental team of experts who collaborate to develop the Office's practice on trademarks and designs. The leaders, or in some cases members of these knowledge circles, are here today and constitute this panel. Please let me introduce Peter Sipos, leader of the knowledge circle Relative Grounds and Inter-Parties Proceedings. Tom Clark, representing the knowledge circle Absolute Grounds and Ex-Party Proceedings and the knowledge circle Goods and Services. Kate Hogan, representing the knowledge circle Register. Caterina Compari, the leader of the knowledge circle Geographical Indications and Collective Rights. And my name is Kelly Bennett. I am the leader of the knowledge circle Designs. And in addition, today I have the honor of being the moderator of this session. So let's begin. The guidelines are structured in different parts. Parts A through M. I think it makes sense to start with Part A, where there have been some interesting changes that concern all areas of proceedings before the Office. Kate, in Part A of the guidelines, which covers general rules and provisions, I see some important changes are to take place on the 1st of March regarding the use of fax. Can you provide us with some more details?
Yes, Kelly, indeed. Important changes will take place on the 1st of March. For the first time since the Office opened, we will no longer be using fax. So the decision of the Executive Director of the Office, that's number EX29 on communication by electronic means, was signed and published on the 3rd of November with a later date of entry into force, namely the 1st of March 2021, which coincides with the release of the new guidelines. This new decision brings in important changes regarding communication. The main one is that fax is abolished as a means of communication, both for the parties and for the Office. And this means that as from this date, the Office will not be issuing any notifications or communications by fax, and also where any party attempts to send the Office a fax, they will receive a negative fax report, as our fax server will no longer be online. It is important to highlight that this concerns all proceedings before the Office, so therefore includes all EUTM and all RCD related proceedings as well.
But what happens when the specific e-action is not accessible in the user area and someone needs to make a submission before a deadline? Because in the past, fax was always the backup alternative to the user area because submitting something by mail takes some days to reach the Office. So what's going to replace fax in that situation?
Indeed. So as fax will no longer exist as a means of communication, this will leave two official methods of communication. On the one hand, we will have the traditional mail or courier services, which will continue, and then we will have on the other the electronic means of communication, which are those communications through the user area, and these are the ones that have been updated with the ED decision. So currently under existing rules where fax is still available, should a user encounter any issues at the time of making a submission online, he or she could revert to fax as an immediate backup option. As fax will no longer be available, as from the 1st of March, the Office has made available two alternative backup solutions, which offer the user access to sending the communication to the Office without having to rely maybe on the delay of sending something by mail or courier. The first is in the user area itself. It's not a specific e-action, but rather in the communication section, there is a button called Communication Backup. It's previously been called Alternative to Fax. There'll be a slight renaming coming in there. Which simply allows the user to upload any file or any submission. So any PDF could be uploaded as an attachment. The second is what we're referring to as a file sharing solution, and it's unrelated to the user area. So this is in order to have a second backup that's not accessible through the user area. So in order to make use of this, the user would contact Information Centre of the Office, who will provide them temporary access to a secure location where they will be able to upload the submissions. This one should only be used, obviously, if they need to meet a very urgent deadline. The user will be required to log into this alternative backup. So it is important to highlight, however, if either of these two backup solutions are used, and what the person is submitting is an EUTM or an RCD e-filing, so a first-time application, the user will still be required to resubmit the identical e-filing within the next 3 working days in order to keep the filing date of the backup. This was already the practice when fax was a backup. So we have changed the backup method, but the same rules still apply for the 3-day resubmission for EUTM and RCD filings. For more information, you can see the guidelines, or you can see also the decision explains this.
Thank you, Kate. You mentioned e-communication, and I know that user area account holders used to be able to opt out of receiving communications by e-com, as they may have preferred to receive faxes instead. As you also mentioned previously, fax will no longer be available after the 1st of March. So where does that leave the use of e-com?
Yes, indeed. The last change I think it's worth highlighting from this decision is indeed that accepting e-communication as a means of receiving communications and notifications from the office becomes compulsory for all user area account holders. So under existing rules, user area account holders could opt out of this means of communication. However, with the entry into force of the new rules on electronic communication with the new ED decision, a user area account holder will no longer be able to opt out of this means of communication while the account remains active. So it is very important to highlight that this applies equally to new and existing account holders, and this includes those that may have previously opted out under the former rules. So as from the 1st of March, all user area account holders, with no exceptions, will be receiving e-communications from the office. At this point, I'd just like to remind that all user area account holders can activate what's alert notifications in their account. So they would receive, for example, an email when an e-communication enters their inbox. So it might be it's very interesting for all user area account holders to activate these alert notifications, so they are immediately informed when an e-com enters their user area.
So indeed, lots of changes ahead. The decision on electronic means of communication isn't the only decision that enters into force on the 1st of March, though, is it? There's also a decision on technical specifications for annexes submitted on data carriers. So what can you tell us about that?
Yes, we've been busy with our decisions. So the decision of the Executive Director, this time it's number EX 2010, on technical specifications for annexes submitted on data carriers was signed on the 22nd of December. And it also enters into force on the 1st of March. And this decision brings in important changes regarding the use of data carriers for submission of annexes. So in summary, the 3 main changes are: it removes DVDs and CDs as acceptable type of data carriers. So the decision now specifies that only USB flash drive or pen drives or similar memory units are acceptable means of data carriers. It also reduces the acceptable size of individual annexes, so individual files, to 20 megs. It explains that the content of the data carrier will become part of the electronic file of the IP right. And as such, the original data carrier may be disposed of 5 years after its receipt. So this decision also explains, there's a few other bits and bobs in there, but it also explains how the name and the structure of the content of the data carrier will be incorporated into the electronic file, and why it's relevant that each annex is correctly named. For example, the files will be incorporated into the electronic file grouped by file type, which may not necessarily follow the same order as the files have been saved on the data carrier, which is why it's very important that each name of the file is correctly identified by the party. So each file is correctly named. So for example, if you have 3 annexes on the data carrier, that one is Annex 1, Annex 2, and Annex 3. Now, why we've done this? So these changes to data carriers will allow, most importantly, will allow for the content of the data carrier to be saved to the electronic file, which for transparency purpose will improve public access to the content of the file. As you know, through eSearch, people can now access online access to files. At the moment, data carriers, the content of data carriers aren't visible in online access to files because they're stored as physical items of evidence. So by converting the content of the data carrier into the electronic file, it will be publicly available. We also have intentionally aligned the size and the formats of the content and also the file limitations that we have in e-actions through the user area. This means that a file that could be uploaded in an e-action in an opposition proceeding is the same size and the same format as one that can be submitted on a data carrier. And this puts the parties that rely on e-submission and those that rely on data carriers in the same position. And finally, from a very practical perspective, it reduces the cases where the content of the data carrier is damaged or becomes illegible over time. CDs and DVDs are the most common. They're very prone to damage over time, either to be scratched or damaged, very easily damaged in comparison to USBs. And that's even if the data carrier has been stored very carefully. So these are the main reasons behind the change.
Okay, thank you. So very important that our users read the decisions of the executive director, but also the guidelines. That's means of communication. So before we move on though, is there any other information on general provisions that you would like to highlight? For example, I saw that the annexes to the section of the guidelines that deal with professional representation have seen some considerable changes. So maybe you could explain what's happened there.
Indeed, professional representation. So Part A, Section 5 of the guidelines is the section that deals with professional representation. And there are two annexes to this section, Annex 1 and Annex 2. So as you may know, in order to act as a representative before the office, a person must first be entitled to act as a representative before one of the IP offices of the member state. And these annexes set out the national requirements for legal practitioners and for professional representatives, which are the two types of professionals, for trademark and design matters in each of the European member states, sorry, the EEA member states. So the annexes are structured in tables and they have rows for each member state and columns for each national provision. So what we did in this update to the guidelines is we've improved the layout. We've introduced new columns for the different type of professional representatives. So for professional representatives, we've separated on the one hand those member states that rely on 5 years experience and those member states where the representative must hold a national qualification. So now, before we had them all in one column, so now we've separated those two. And also what we have done is we've updated the content because obviously the guidelines were also reviewed by the national offices, and we have received quite a lot of feedback from the national intellectual property offices on different changes in their national provisions. So we've also updated where a national IP office has informed us of a change or where something needed updating or was maybe outdated or needed correcting. We've updated that. So we've updated the changes to the national provisions. But that's why it looks, it's everything. If you look in the track changes version, it's all red, but mainly it's because of the restructuring.
Okay, so clarity and updating basically in that regard. So let's move on now to some formality issues. Tom, it looks like advances in technology mean differences in the way we examine formalities. Can you tell us a bit more about this?
Sure. If an application has a list of goods and services filed separately or in an attachment, this is not considered to be an electronic filing, and so it can't benefit from the reduced fee for an electronic filing. There was a decision of the Executive Director in November last year, number 29, which set out the new rules for communications by electronic means, as Kate's just mentioned. So in cases such as these, if the fee hasn't been correctly paid, the office will raise a filing date deficiency. And the filing date will only be established once the fee's been paid. And if the fee for paper filing is paid within a month, the filing date will be maintained. Otherwise, the filing date will be the date of payment.
Excellent. There was always a bit of a problem with regards to languages and translations with lists of goods and services as well, wasn't there? Has there been any clarity provided in that respect?
There has, yes. As we know, you can file an EUTM application in any of the 23 official languages of the EU, and you have to select 2 languages in the application, the first and the second. Let's concentrate on cases in which the first language is not one of the 5 office languages, and so it's not going to be in English, French, German, Spanish, or Italian. The applicant has the option to file the translation of the goods and services in the second language, and that will be one of the office languages I just mentioned. This has got some legal consequences which need to be underlined. So when the translation is provided by the applicant, it's his responsibility to ensure that both versions are aligned. And the office only points out obvious discrepancies. This means that the second language becomes what's called the reference language. And in a case of discrepancy between the language version, this will be the one that prevails. And this is according to the regulation. This explains why the classification is examined in the second languages in these cases. And as a consequence of this, if there's a limitation following, for example, a classification issue or an absolute grounds deficiency, the applicant will have to file a new list of goods and services. And this can be done in two ways, either filing it in both language versions or only in the first language. If this is done in the first language, the office will provide a translation in all of the languages, including the second one. What can't be done is to file it only in the second language, because the office can't translate from the second language into the first one. So please don't be surprised if you're requested to file both language versions. And if you want to file only one version, do make sure it's filed in the first language.
Thanks, Tom. I think there have been some updates or clarifications regarding the formal requirements for collective and certification marks as well, haven't there, Katarina?
Yes, indeed. We have taken the opportunity to make the guidelines more user-friendly. And now all formality issues regarding both collective and certification marks can be found in one place, instead of looking back and forth within different chapters of the guidelines. Apart from putting all the formalities in one place, for collective marks, further explanations have also been added on. For example, how to include a reference to authorized users, or why, for example, the use of licensees or similar references should be avoided. With respect to certification marks in particular, the requirement regarding the characteristics to be certified in the regulations of use has been clarified, reinforcing the existence of a link between the applied goods and services and the characteristics applicants wish to certify. This particular link, as practice so far has shown, is missing in majority of the cases. Finally, we have reinforced the fact that characteristics being certified cannot relate to service providers themselves.
Thank you for that. Now let's turn to Kelly. There must have been some changes in relation to designs as well, no? I saw some news items in Alicante News about the office joining EUIPO DAS. So I'd imagine this has been reflected, has it?
Thanks, Tom. It's awkward being the moderator. I can't ask myself questions, so thank you for the interview question. Yes, as you said, the EUIPO has implemented EUIPO DAS as the Office of First Filing and the Office of Second Filing during the course of last year. What this means is that applicants can ask for a EUIPO DAS access code for submitting to other offices where they wish to claim priority from their RCD application. And they can also indicate a EUIPO DAS access code as a way of submitting evidence for priority claims they make in their RCD application. All of the requirements for both of these aspects are explained in the guidelines. But there have also been some other important changes that I wanted to tell you about. First of all, a particularly important change is in relation to paragraphs 3.3 and 5 of the examination of designs guidelines regarding the representation of the designs. The guidelines have been structured to clarify the difference between filing date deficiencies and their consequence, and with a reference to Jägermeister, the case law of the General Court, and formality deficiencies relating to the views and their consequences. And finally, also in relation to the formal requirements for designs, another important change in the guidelines, and indeed in this case a change of practice, is with regards to the ex officio changes in product indications. In order to reduce deficiencies and enable the speedy processing of applications, deficiencies relating to product indications containing an obvious mismatch will now be replaced ex officio by the examiner. I believe there's also been some changes regarding classification of goods and services, Tom. Last year, I seem to remember that you made some changes in the way that limitations can be made. Have you made any progress with this in 2021?
Yeah, we have. We've added clarification to explain the distinction between amendments and restrictions. in a better way. Amendments, that means changes in wording that don't necessarily limit the list of goods and services, can be made before registration, obviously without widening the scope. It's worth noting that this isn't possible after registration, when it's only possible to limit the list of goods and services. We've also added examples of amendments and restrictions, and so this part's far more complete. We also now show criteria according to which restrictions and amendments may be accepted or rejected, including subjectivity, targeted public, the intended use or purpose, subject matter, and also the theme.
Excellent. So more clarity provided in that respect then. While we're still on the topic of formal requirements, could you tell us about some of the changes that have been made in the guidelines in relation to inter partes proceedings, Peter?
Yes, thank you, Kelly. Good morning, everyone. Indeed, sometimes oppositions are filed by multiple opponents, by several opponents. And we clarified that this can only be done if all the opponents have some kind of entitlement to all the earlier rights claimed as basis of the opposition. Now, sometimes this follows from a legal change, in fact, because prior to the entry into force of the changes brought about by the last legislative reform in 2017, it was enough if at least one opponent had some entitlement to all of the earlier rights. The second, third opponents need not have had entitlement to each of the earlier rights. So if you look at it from that angle, the rules have become more stringent. And we listed in the guidelines we provided some acceptable and non-acceptable scenarios as examples for users' benefit. An acceptable scenario would be when opponent number one owned all the earlier rights on which the opposition is based, and opponent number two was, for example, a licensee to each of those earlier rights. Or where opponent number one owned all the earlier rights and opponent number two was co-owner for earlier right number one, or A, and licensee to mark number B. So these would be examples of acceptable combinations of opponents. But what we often see in practice, unfortunately, are mistakes like opponent number one would be relying on his mark A, whereas opponent number two would be relying on his own mark B. So in that case, this is not an acceptable, admissible combination of opponents, and we would raise a deficiency notice. Now, it's very important to comply with the deficiency notice, and in fact, we are inviting the opponents to select one of them to continue the opposition with. And the earlier right of the departing opponent would no longer be taken into account for the purposes of the opposition. If this deficiency is not remedied, then unfortunately we have to reject the opposition as inadmissible in its entirety. And this is because the office can't ex officio select one from the multiple opponents to continue the proceedings. But deliberately I'm leaving the most important message to the end, that all these complications, possible complications with multiple opponents, can be so easily avoided if only one opponent filed an opposition, because according to the EUTM delegated regulation, it is where an earlier right is owned by several persons, or several persons have other type of entitlement to the earlier right, like for instance licensee. It's enough, it's perfectly sufficient if only one of them enforces this earlier right in an opposition. So all these possible problems from multiple opponent scenarios can be easily avoided if in such a situation only one of the owners are opposing.
Thank you, Peter. So some important clarifications there for our users and examples to help. There used to be a table that summarised national law provisions for determining the date when a national mark can be deemed registered for the purposes of calculating the 5-year grace period for non-use. That table disappeared in previous guidelines. Can you tell us what's happened now?
Yes, indeed. We had to remove this table in the previous guidelines revision exercise back in 2019, beginning of 2020, because there have been quite substantial, considerable changes in national laws in this respect, on occasion of the new harmonization directive. Now the good news is the table is back, and it even includes a new additional important feature. But in order to give a little bit of context to this, so we know that the possibility of the applicant to require the opponent to prove genuine use of the earlier marks on which the opposition is based is probably the most important defense plea of the applicant in an opposition. Such a request is admissible only if the earlier right has been registered at least for 5 years as at the date of filing or the date of priority of the contested trademark application. This is what we colloquially refer to among ourselves as the 5-year grace period for non-use. Now, when it comes to earlier national registrations, it has always been the practice of the office to take as basis, as reference for its calculation, the date of completion of the registration procedure. We deemed the marks to be registered on the date of completion of the registration procedure as provided in the harmonization directive. Now, although the concept is there in the harmonization directive, date of completion of the registration procedure, the concept itself is not fully harmonized. And it has not been fully harmonized even in the last iteration of the harmonization directive. So, which leaves us with quite a lot of disparities. Immediately to mention one is that there are a couple of member states who have post-registration opposition systems. In that case, obviously, we cannot take the date of registration as the basis for our calculation, because the proceedings that still does not necessarily mark the completion of the registration procedure. But even considering those member states where have more that rely more on that do not operate a post-registration opposition system have disparities, and the harmonization directive did try to mitigate the effect of these disparities by requiring member states to publish in their registers the relevant date for commencement of the 5-year grace period for non-use, but only a handful of member states have dedicated up to now a specific entry in their national databases to this field, to this data, namely the date of commencement of the grace period for non-use. So, in order to help both our examiners in our first place, but also users, for the sake of more transparency, we recreated the previous table, so to say. We updated it. We updated the relevant national legal provisions. But in addition, and more importantly, we added an additional column which contains information as to the specific place, the specific heading where this particular date can be found in national database extract. So we are hopeful that this will assist both the parties and also our examiners to determine with accuracy, to calculate with accuracy the grace period for non-use. So that is so much about national marks, but there have been also some changes with respect to earlier international registrations designating member states. Now, in this case, we clarified in the guidelines that if the relevant international, if a statement of grant of protection has been issued for this international registration, then we will no longer calculate the grace period for non-use on the basis of the so-called tacit acceptance. We know that there is this concept in relation to international registrations that after 12 months or 18 months, it should be deemed to be accepted for protection in the designated member state. And for a long time, the office has taken that date as a reference. But we decided to move a little bit closer to reality, closer to accuracy, by taking as new point of reference when a statement of grant of protection has been issued, the date of publication of that statement of grant of protection by EUIPO. And why not the actual date of grant of protection, you could ask? Well, the answer is quite pragmatic, because that date is not published by EUIPO in the Madrid Monitor. So that's not easily and widely accessible. And so we took this new reference date for the purposes of our calculation. But what I would like to emphasize, and now allow me to revert a little bit also to the table, that wherever parties would consider that the calculation done by the office is not correct, they can come back to the office and prove an earlier, or as the case may be, a later relevant date for the purposes of proving that the earlier mark is not yet subject to the proof of use requirement, or it is subject to the proof of use requirement. So we do keep the door open and allow parties to claim a different date, but only if it is relevant for the purposes of determining whether the earlier, because we saw that in the vast majority of the cases, it does not really matter. There is such a time distance between the earlier mark and the contested mark that even without accurately defining the relevant date, the earlier mark would be old enough, so to say. And just a last remark as to the table. Of course, this is a living document. There are legal changes. There may be changes to the database content. So the office is watching and monitoring. And as soon as we receive information from parties or national offices about any relevant change, we are more than happy to include it in the next update of the guidelines. I hope this explains.
Very much. Thank you, Peter. I think our users will be very happy to see that table back. We heard a lot from them when we removed it, so I'm sure they'll be very happy. Tom, have there been any aspects of absolute grounds that have changed over the past year?
Yeah, there are a few areas which have had slight changes following case law. So names of colours, for example, will now only be objected to when the colour constitutes an objective characteristic of the project, which is inherent to the nature of the product and intrinsic and permanent regarding that product or service. We've also looked into the concept of accepted principles of morality to show that this refers to the fundamental moral values and standards to which society adheres at a given time, and that there are some aspects of context that can be relevant in assessing this morality.
And talking about morals, are there any changes in the way we look at bad faith?
Well, we've added an example of when the intention of the applicant is dishonest. That's to say, when an application is made and there's no intention to use the trademark in relation to some or all of the goods and services which have been applied for. This might now constitute bad faith in some circumstances. For example, if the applicant for registration was intending to undermine the interests of a third party or was trying to obtain an exclusive right for purposes which weren't within the function of a trademark.
Thank you, Tom. Katerina, have there been any changes this year in relation to collective and certification marks?
Yes, indeed, there have been several changes worth mentioning today. As many changes are reflected in the chapter on collective marks, I will start with those first. Several issues have been clarified in this new edition of the guidelines. Namely, following the recent case law, the office has provided more information on the application of Article 74.2, or as we know it, the so-called Geographical Derogation, which is prescribed in relation to collective marks. Pursuant to Article 74.2, by way of derogation from Article 71c, signs or indications that may serve in trade to designate the geographical origin of the goods or services may constitute EU collective marks. However, Article 74.2 is not an exception to the requirement of distinctiveness. It should not be forgotten that both Article 7.1b and Article 7.3 apply to EU collective marks as well. Therefore, when an association applies for registration as an EU collective mark of a sign which may designate a geographical origin, it must ensure that the sign has elements that enable the consumer to distinguish the goods or services of its members from those of other undertakings. In other words, a sign applied for as an EU collective mark must have elements capable of distinguishing the goods or services of the members of the association from those of other undertakings to be considered distinctive within the meaning of Article 7.1b. Therefore, the Office will assess on case-by-case basis whether the signs containing geographically descriptive terms, including here geographical indications, contain elements that are sufficient to render the mark distinctive as a collective mark. Finally, trademarks that may serve in trade to designate the geographical origin of the goods and services must in any event comply with the authorization set out in Article 75.2. Well, this in essence means that such collective marks must authorize in the regulations governing use any person whose goods or services originate in the geographical area concerned to become a member of this particular association. The Office further provided examples in respect of Article 76.2 and the possible misleading character of a sign in the view that the main function of a collective mark is to indicate the membership of an association. Therefore, and as an example, in case of a collective mark consisting of a geographical indication or a respective logo, the public is liable to be misled as the sign may be taken to be a geographical indication rather than a collective mark. Finally, with respect to both collective and certification marks, the Office recommends the applicants to use the templates which are available online to help them throughout the drafting process for the regulations of use.
Thank you, Katerina. While I have you here, do you want to tell us about any changes in relation to geographical indications?
Yes, absolutely. As you may know, the European Union joined the Geneva Act of the Lisbon Agreement on appellations of origin and geographical indications, which entered into force on the 26th February 2020. Consequently, this new reality has been added to the guidelines in respect to geographical indications, where it is explained that geographical indications from non-EU countries protected at EU level by the Geneva Act can form basis for objection under Article 7.1j. GIs originating in non-EU countries protected under the Geneva Act of the Lisbon Agreement can also be relied in the oppositions under Article 8.6, well, provided that they were granted protection in the EU. Information on the relevant date for establishing priority and on the scope of protection conferred to those GIs has also been included. And well, apart from this international perspective, the changes reflected in the guidelines address some issues where the practice has shown that change is required. For example, the Office will suspend the ex officio proceedings where the objection is raised due to the conflict of a trademark with a geographical indication, but where the geographical indication application has not yet matured to registration, in case the applicant does not submit observations or does not overcome the objection. This will equally apply to trademarks in conflict with traditional specialties guaranteed. Also, the Office will no longer object ex officio to trademarks in conflict with GIs that are applied for transport services. Transportation services are provided by specialist transport companies whose business is not the manufacture and sale of the goods covered by the GI. Finally, the references to Commission databases and registries have been updated in view of the creation of Ambrosia database, which contains information regarding geographical indications protected at EU level in the wine, aromatized wines, spirit drinks, and agriculture products and food subsectors. But speaking of geographical indications databases, I hope you have all already used the recently launched GI View, which includes not only the geographical indications registered in the EU by the application to the Commission, but also GIs coming from third countries and protected in the EU through bilateral agreements with the European Union. For some GIs, in the GI View, you may already find additional information, such as photos, interactive maps, as well as references to producer groups and control authorities, which I'm sure will interest many. Thank you.
Thank you, Katerina. So everyone take note, go check out GI View. So let's delve a little bit further into inter-parties issues. Tom, I know Knowledge Circle Goods and Services has been struggling to bring clarity and precision to comparisons. Can you tell us whether you've cracked the code this year?
Yeah, well, terms which lack clarity and precision really are a constant problem. So we've clarified the practice on how these will be interpreted and compared. This will depend on whether the unclear and imprecise term is in the earlier mark or in the contested sign. If we've got any unclear and imprecise term in the earlier mark, we can't exclude it from the comparison from the outset. However, we won't be able to find similarity when the natural and literal meaning of a term like this could coincide in relevant similarity factors with the contested goods and services. And then in the opposite case, if we have a term which lacks clarity and precision, and this is found in the list of goods and services of the contested mark, then the office will reopen the classification so that this can be clarified. So
some clarity and precision there anyway. Are there any other problematic areas that you've managed to clarify?
Yep, we've also been working on the concept of complementarity. We've clarified the definition of what this is, and we've also elaborated on factors such as the connection between the goods or services, the relevant public, or the origin of the goods or services. We've also added more explanations and examples to illustrate this, and obviously made reference to the relevant recent case law. And we've expanded on the idea of functional complementarity, adding explanations to show that functional complementarity can be found in cases of comparisons between a final product on one hand, and then its parts and components and fittings on the other.
So goods and services are a hot topic this year. I think, Peter, you've had to tackle goods and services, but from a different angle. Can you tell us a bit more about that?
Indeed. According to a well-known definition, retail services are the bringing together for the benefit of others goods so that the consumer can view them conveniently and purchase them. And this definition has been also confirmed in case law. We know from case law that retail services comprise, beyond the actual sale transaction, the legal sale transaction, all the activities that go together with encouraging, promoting the sale of goods to consumers for the benefit of others. Now, we clarified in this new edition of the guidelines that just like in the case where a trader would be advertising its own goods, that would not qualify as advertising services, as independent advertising service. In the same way, if somebody is selling its own goods from its own either physical or online outlet, this does not qualify as retail service as such. If a manufacturer is selling its own goods from his own shop, this is an activity which is totally integral to the activity of the trader, of the manufacturer, and this activity is covered by the registration of the trademark in relation to the goods. You don't need retail service protection for this activity to be covered. This is an integral activity to the sale of the goods is an integral activity and not an independent service. So what this translates into the proof of use context, that whenever we are checking whether the earlier mark was used in relation to retail services for goods, and the proof shows only and exclusively that the owner was selling its own goods from its own shop, we would not accept it as proof for retail services. Now, it would be one of the reasons, and that we also included in the guidelines, that it would be inappropriate to equate the protection for registrations in the goods classes, say from class 1 to up to 34, to single protection of retail services in class 35 in relation to those goods. Also, we consider that in any such case, when a manufacturer is selling its own goods from its own shop exclusively, he is not really competing on the retail services market, targeting other third-party manufacturers, but rather he is competing on the relevant market for the goods concerned. I hope this clarifies.
Thank you, Peter. Tom, can you ask me a question, please?
I can ask you a question, Kelly, yes. I think it's just about time for that. Your knowledge circle is responsible for inter-parties issues in the form of RCD invalidity. So let us know what the most important changes that have been made in the guidelines in that area, could you?
I can, thank you very much. So several clarifications have been made in the guidelines on examination of design invalidity applications. The most important of these are in paragraphs 310.1, statement of grounds, and 310.2, facts, evidence and arguments, where here the guidelines have been amended to clarify that the application form indicating the grounds on which the invalidity action is based is considered to be a statement of grounds in accordance with Article 28.1.5i CDIR, but it is to be complemented with facts, evidence and arguments in accordance with Article 28.1b6 CDIR for admissibility purposes. So when the application form is not accompanied by such facts, evidence and arguments, the office will send a deficiency letter inviting the invalidity applicant to remedy this deficiency. And to successfully remedy the inadmissibility deficiency, the invalidity applicant will have to submit a statement of grounds explaining the grounds and providing all the necessary factual elements of the case. In other words, the mere reproduction of the wording of the relevant legal provision is not sufficient. If the applicant does not remedy within the prescribed deadline, then the application will be considered inadmissible. As regards the extent of the admissibility examination, when several earlier rights or grounds are invoked, and in order to clarify current practice, what we've done is amended the guidelines to confirm that the invalidity applicant is to submit a complete certificate of registration of the earlier design or right, except when that earlier design or right is an RCD or an EUTM. And furthermore, it has been clarified that the submission of extracts from Design View and TM View is under the responsibility of the invalidity applicant, and that where the applicant does not submit a complete certificate of registration of the earlier design or right, a deficiency letter is sent giving a deadline to remedy. Also, we have updated paragraph 310.3 on the admissibility in respect of one of the grounds or the earlier rights relied on. So it clarifies the current practice where we examine the admissibility of the invalidity action just with regards to one earlier right or ground invoked from among several. In addition, what has been clarified is that if during the proceedings it becomes clear that the decision cannot be taken on the basis of that earlier right or ground that has been found to be admissible, the other earlier rights or grounds have to be taken into account, and the invalidity division must proceed by checking the admissibility with regard to those earlier rights and grounds, and where necessary, it will send a deficiency letter giving the invalidity applicant a deadline to remedy. Only once the admissibility is remedied or the deadline has expired without remedy can the invalidity division take a decision. And finally, another important change, which constitutes rather a lot of changes in the track change version of the guidelines, is in relation to disclosure of the earlier design. This whole section has been reviewed in order to reflect the two-step analysis supported by case law, and to reflect under a separate subheading the specificities of design disclosures on the internet as contained and agreed in CP10. Finally, the paragraph on individual character has also been updated with respect to the four-step test of assessment of individual character established by case law. The implementation does not mean a per point technique, but rather a general principle, a coherent test, taking into account all the relevant factors such as sector and type of products concerned, informed user, freedom of the designer, and the comparison of the designs with a conclusion on their overall impression. So just to move on to the final part of the guidelines now, which is part E, perhaps Kate, you could tell us about any changes in that part, which is the section that deals with post-registration actions and third-party rights.
Yes, Kelly. We made a few changes to part E. We've inserted some clarifications. We've inserted some case law. We've improved some examples, but there are actually no changes of practice at all in part E of the guidelines. So just to name a few, in the renewals section, we've clarified the situations where payment alone is deemed to be a request for renewal. So this is foreseen in the regulation. However, we have also clarified that if this type of renewal is relied on, that the discounted e-renewal fee of €850 cannot be relied on. So obviously, if you're relying only on the payment of the fee and you're not making an e-renewal submission, then the full fee of paper renewal, so the full €1,000 must be paid. So e-filing for renewals can only be relied on where an actual e-filing application for renewal is submitted. For partial renewals, we've clarified slightly the parts on the 25% surcharge. This is late payments. And we've clarified that it's the 25% is calculated based on the belated part of the payment, not on the full renewal fee. There seemed to be some confusion there before. So where some had been partially renewed already, in the grace period or later on, a second part is renewed and that part is belated, then obviously you only pay 25% of the part you didn't pay on time. In the inspection of files section, we have included some explanations on potential, we're calling them ex officio marking of confidentiality, but it's on the part of confidentiality. And it's where the office on its own initiative could mark something as being confidential. For us, we were considering these would be documents that are submitted in files such as passports or other ID documents, which we normally see attached to transfer requests, where they submit all the evidence of the transfer. Maybe there's a contract for the sale of the trademark, and there could be some passports or some IDs attached at the end of the paperwork. So we've clarified that in these cases, obviously, there's no public disclosure or no need to have the public disclosure of these passports and ID, even if confidentiality is not invoked. We're also thinking, for example, if a request for restitution interim was requested and it was based on health matters, or someone's health data obviously is not of public interest, therefore we could also mark that as confidential. And we're also thinking that sometimes people, in order to prove that they've made a payment, even though we've received the money, would attach a printout, a bank extract, a bank account extract that could contain some personal information regarding their bank account. So obviously in those cases, we could also mark them. So overall, no changes, a number of clarifications, a number of rewording, but that will be my highlight maybe of part E.
Thank you very much, Kate. I would propose that we close this panel discussion now. And I'd like to thank all of the leaders for their explanations about these interesting changes, which perhaps I can try and summarize. So, in relation to general provisions, fax is abolished as a means of communication. E-com becomes compulsory for all user area account holders, and DVDs and CDs are no longer acceptable data carriers. In relation to formal requirements for trademarks, we have clarifications about when a list of goods and services becomes a filing date deficiency, and how to deal with their translations and the differences between amendments and restrictions. All formalities for collective and certification marks can now be found in one place. For designs, specific reference is made to EUIPO DAS. Filing date and formality deficiencies for graphic representation is clarified, and there is a new possibility for examiners to make ex officio changes to product indications. As regards inter-parties proceedings, there is information on when multiple opponents are admissible and clarification on the calculation of the grace period for non-use. In the area of absolute grounds and geographical indications, the section on names of colours has been updated in line with case law, and bad faith sees some more examples. The templates for regulations governing use are available online, and clarifications have been provided for Article 74.2 and geographical derogation, and examples for collective marks and Article 76.2 misleading character. Finally, in regards to the substantive aspects of inter partes, the guidelines provide clarity and precision to both of these notions in relation to lists of goods and services. The issue of complementarity has been further developed. It has been clarified that the sale of one's own goods from one's own shop is not retail services. And in relation to designs invalidity proceedings, clarifications have been provided as to the different requirements for the statement of grounds and facts, evidence and arguments. And the section on disclosure of the earlier design has been updated in line with CP10. Now, as I mentioned at the beginning of today's webinar, the new edition 2021 will be published online on the 1st of March. However, for technical reasons, the 2020 edition will be marked as obsolete a few days before, while the 2021 edition is being processed. This means that the 2020 edition will appear online with the obsolete watermark as of Friday, the 26th of February, even though it will still be valid until the 1st of March. So with the panel discussion closed, I think we can now move on to try and answer some of the questions that we have received during our discussion. So let me see if I can find them. And we can start with Kate. I see rather a lot of questions for you. The first one is, if fax is no longer available, how do I assume representation for the EM part of an international registration? I don't know if you understand the question, because I think it's confusing two things there, but perhaps you can clarify for us.
No, I'm assuming, so it's one of these, we don't know when we're live, but I'm assuming the person that's asking the question is a professional representative. And my assumption is therefore that she's asking where she wants to take over. So here we're talking about international registrations that designate the EU. So we're not talking about direct EUTMs. So she's just saying, how can I take over the professional representation of a European trademark that's an EU designation? So I was just I just checked online. There's an e-action, not so much an e-action, there's an e-filing available. So in the user area, this would fall under the category of e-filings that are recordals. So you would select the e-filing of the recordal, and you have the option to select change of representative. When you select the change of representative, you then have the option of either, there's different ones there, but you have appointment and replacements if you're being appointed as first-time rep or replacing an existing rep. There you have three options. You would have EUTM, RCD or others. So international registrations fall under others. And if you do click on others, you will have a drop-down menu. And there you would have all different proceedings before the office. I think opposition proceedings are there and things like that, but one of them is international registrations. So even though fax, let's say, is not going to be available, this is an e-action, or it's an action that can be carried out through the user area. So you would need to have a user area account for this, obviously, but it's one of the e-filing solutions there. Sorry. I was actually going to say, Kelly, if you want, I'll take over, because I've seen, as I said, I was watching all the questions coming in, so I've sort of got them in my head structured in one way.
Fine by me.
Yeah, I'll take over for the next 3 or 4 questions. I did expect, I had the juicy topics of the morning, so I did expect to receive some. So I accidentally answered live a question, apparently, which I apologise, I haven't answered it yet, but I'll be answering it right now. There's a question, so now we're referring to data carriers. There's a question here from a user saying, well, regarding the fact that we've reduced the size of individual files on a data carrier, and she says, or he says, that normally data carriers were chosen by the parties precisely due to the fact that e-actions and websites restrict the size. in order to incorporate to the proceedings larger files that the website does not accept. So in other words, we're saying we would usually rely on a USB because we wanted to submit something bigger that could not be submitted through any action. And the question is, don't you fear the risk of complaints from users regarding this alignment? I think my initial answer to that was, well, potentially whenever we change the practice in any area of proceedings, potentially there's always a risk for complaint. Obviously this is change and it brings its complications. So on the one hand, I'd like to highlight, for data carriers, the executive director can determine the size of the formats and the technical restrictions of a data carrier. When assessing if we reduced the size of what could be saved on a data carrier, and we aligned it and we looked at what we were allowing in the e-actions, of course this concerns mainly inter partes proceedings. I'd say data carriers are relied on more commonly in opposition and cancellation proceedings than in any other proceeding. And therefore it's also the type of evidence submitting. Here we're not talking about trademark or design representations. Here we're talking normally, I would assume the question comes in line from MP3s and MP4s. So normally we're talking MP4s, promotional videos and evidence of use in inter partes proceedings. So at the time we balanced, the size 20 megs for individual file is substantial. It's not huge. Admittedly, I'd say what we had before the 200 was excessive. So we have, it is, if you look at what we were accepting and what we are, there's a big jump from 200 to 20. But 20 is substantial. On the other hand, we have to balance the interest of the users that want to rely on data carriers and they want to submit annexes on data carriers because they want to send in, I'm just saying promotional videos for the purpose of this exercise, but generally I concern MP4s. But we also have to balance this with the technical aspects of processing. And as I said, the idea is we want to incorporate these in the file. And here we have to bring into balance third parties' interests, either the other party in the inter partes proceedings or just other third parties that are unrelated to the proceedings. Because if the outcome of the decision, for example, was that the opposition was upheld based on this evidence, it is in everyone's interest that we make this evidence publicly available. So if we have huge files that we can't upload into our back office, we can't make available in online access to files, then it's not in the interest of any third parties or the other parties. So it's a huge balancing act of interest of the party making the submission, where we think that 20 is considerable size, interest of the office when technically physically being able to upload these into our back office, and thirdly the access to online access to files for third parties. Worth highlighting, if again I'm assuming MP4s are the big one here because I can't see that PDFs or TIFFs or JPEGs of in excess of 20 meg would be necessary. I can see maybe only potentially MP3 MP4s going to in excess of 20. There's a couple of options. Obviously reducing the quality. We don't need a full HD 4K promotional video. It could be of a lesser quality, obviously assuming that the lowering of the quality doesn't deflect from what they're trying to show us in the video. Also it can split into a couple of files, as in we can have if it's a long video and it requires, it could be split into part 1, part 2, part 3, each one in individual, not exceeding the 20. So that would be my answer to that. So it's a very long question. I mean, yes, potentially there will be complaints, but potentially there's also benefits to this. And actually, if you allow me, because we've seen another question here. Sorry, my mouse has just given up on me. We've got another question on data carriers, and it's from a different aspect. And really, while it refers to data carriers, I think it refers to keeping the files in general. So the question is from a colleague who's asking regarding USB files, so regarding data carriers, and the incorporation of these data carriers into the electronic file in order to make them publicly available. There was some concern because I did mention, and it's in the decision of the executive director, that once a USB or once a data carrier is incorporated into the electronic file, potentially we can proceed to destroy this USB. And the destruction is actually set as 5 years from its receipt. So the colleague's concern is what would happen if, for whichever reason, we didn't upload the full content of the USB, there was a technical error or something, 5 years pass, we destroy the original, but then the parties still need to rely on this evidence. It's an elaborate question. I mean, obviously, yes, it could happen. I mean, on the other hand, I think a 5-year period, because we're uploading to the files and we're forwarding in the proceedings, I think normally within months it would become if we'd omitted to upload a file, or there was something there that we hadn't uploaded, it would normally be months, potentially a year, but normally it wouldn't reach the 5-year mark of someone pointing out that we haven't updated it, but how potentially it could happen. But this leads me to the General Office's practice on keeping of files. So we have, there's an existing decision of the Executive Director called on the keeping of the files, and it was updated, I believe, in May or June last year. But generally we separate two types of evidence. So we have anything that forms the basis of the electronic file, and this is not only data carriers, this is, say something was sent in by courier. If we received evidence in paper, we scan it or we link it to the file. So that original item of evidence, because it now forms the basis of the electronic file, can be destroyed within 5 years from its receipt. However, anything that's not uploaded, that's not in the forms the basis of the electronic file, so it's not available and online access to files, we only destroy 5 years after the death of the IP right in question. So we keep that evidence for a longer period of time. To my knowledge, until now, we still, even though potentially we have data carriers that go back years, we keep these in archives. We have a storage system, and at the moment we are keeping them all. So right until now, even though potentially we could have actually destroyed them, we haven't actually destroyed any yet. But as I said, I think, referring back to the colleague, I think it would be identified sooner. I don't think it would take full 5 years for someone to realise, either because it's either the party making the submission, or if the party making the submission refers to the files, he would refer, I don't know, to the MP4 or to the promotional video that's not there, then the other party would immediately point this out. The examiner would realise this. There would be lots of things happening there. So that would be my main one, I think. And that was it.
Good, thank you very much. Hopefully that's clarified all of the questions in that respect. Peter, I see we've got a number of questions about the proof of use in relation to goods and services. One question is, does this mean that if somebody registered his mark, for example, in class 25 for clothes and class 35 for retailing of clothes, but just sells his own clothes in his own shop, in the case of proof of use, class 35 will not be proven? And then I also have another question on the same topic where they ask whether you could clarify what the grounds were for this change.
Yes. So first of all, this is not a change of practice. We have applied this practice in this office for some time now. It is just that the moment has come to reflect this and clarify this in the guidelines. We were also building on recent case law. I particularly refer to the Burlington judgment of the Court of Justice, which has been handed down recently, and it is reflected in the guidelines in the relevant section. So to answer the first question, yes, indeed. So if as I explained, if somebody is selling exclusively his own goods from his own shop, that's not retail service. That is covered by the protection of the trademark in relation to the goods. If somebody has the mark registered both in class 25 for clothing and retail of clothing in class 35, as the example goes, genuine use will be then proven for class 25, and this opponent will win the opposition against the applicant, say against class 25, or even against contested application for class 35, because we have a settled practice that we will accept similarity between goods and the retail of those goods. So nobody is losing out anything here. Just to highlight a little bit more, the ground for this long-standing practice of the office is it essentially derives from the definition of retail services, as also confirmed in case law, that it is for the benefit of others, so as to allow the consumer to conveniently view and purchase the goods. So this definition contains both the others and the consumer. So by default, the two cannot be the same, because otherwise grammatically it would not be correct. So who are the others? The others are the third-party manufacturers. So the retail service is, and as I try to explain, a trader who is operating on the retail services market is targeting third-party manufacturers. He's trying to get third-party manufacturers' goods in his shop, in his retail shop, so as to provide a wide assortment of goods for the consumers to purchase.
Before you go, Peter, there's another question that's come in with regards to the calculation of the 5-year period in a proof of use request. Is the time period for which proof of use is to be shown to be included in the standard letters? I presume this means that the time limit that we calculate and whether we include that calculation in the standard letters when notifying the party. I caught you on the fly there, sorry. No.
It's a question about templates, or probably a question from a colleague from within the office. Nothing is changing in the templates.
Thank you very much. Katarina, I see a rather long question about geographical indication databases. Perhaps you could summarize the question so that we can understand it better and provide an answer.
Yes, thank you, Kelly. Well, the question is on the myriad of GI databases that used to exist and what we have today. So the person is asking what happens to DOOR database and the references to different databases that we have in the still current guidelines. And I just wanted to clarify all the references to anything else except Ambrosia, which is now the official register by the Commission on the protected GIs within the EU, will be removed or are already removed, and you will see them, as Kelly explained, a bit later on this year, in a couple of weeks' time. So from now on, you will only have references to Ambrosia, be it for wines, be it for spirits, be it for foodstuffs. Everything will reference to Ambrosia database. The second part of a question is a bit of a reference to GI view. To be able to answer this part of a question, we have to understand what is GI view and why is it different than Ambrosia and what it allows more, in a sense, more than Ambrosia. So GI view has two sets of information, and I will be very brief here to maybe dispel some misunderstandings. So the first set of information is the mirroring of the official data from Ambrosia. And the second part of the data that I said you can already find for some of the geographical indications is actually data that does not exist in Ambrosia, but which many users might find useful. So thank you.
Thank you very much, Katarina. We have another question about the editions of the guidelines being published in PDF format. I think I can answer this myself, hopefully. The question is that the guidelines used to be in PDF format, had a broader content than on the web text. And the question is whether there are up-to-date broader guidelines in PDF format. First of all, the guidelines in PDF format were not broader than the ones available online. The guidelines that are available online are the full text of the guidelines in HTML format. We always recommend that you consult the HTML format guidelines because there may be changes. These changes are always highlighted when there's been a change in the text. But if you did want to be able to have a PDF format, you can download a PDF version of the guidelines from the HTML version itself. On the introduction page, there is a button at the top right of the screen which converts the entire section or the full text of the guidelines into PDF format. And if you wanted to create PDF versions of individual sections, chapters, or pages, you can do that by clicking on the individual page concerned. As far as I can see, we have no further questions. So I would like to take this opportunity to thank all of my panelists today for joining me in this webinar and for sharing their extensive knowledge on the topics they have presented. And to thank you all as well for staying with us, for showing your interest and for your attention in this webinar. Thank you all very much and goodbye.